Welcome everyone to Affin Bank's webinar. I'm Melissa Ong. We are streaming live on Microsoft Teams. Now today, we are going to talk about understanding moratorium and your contracts during the COVID-19 pandemic, especially on the legal perspective. But before we dive into our hot topic today, I want to explain a little bit more about why we are bringing this topic over the live stream today. So, as you all know, the pandemic have not only affected lives, but livelihoods as well. As a business owner, as a parent, the uncertainties of our economy naturally scares me. It scares everyone. On 28 June, the government announced another 6 months moratorium to all individual borrowers and micro enterprises. Will we still be able to provide for our family? How long will I be able to sustain? What are the drastic changes in our lives that we will have to make to survive? Joining us today is our guest speaker, Ms. Yap Poini, a lawyer who is one of the founders and currently the managing partner of Teo Pek Wei Advocates and Solicitors. In over 14 years, Poini has advised and represented numerous domestic and international clients in various commercial and civil litigation. And our moderator, Kelvin Gun, is the head of wealth management of Affin Bank. He has over 18 years of experience in the wealth management industry. So both of these combined together are the perfect individuals to discuss the topic with today. Over to you, Kelvin and Poini.
Right. Hi. Good afternoon. Thank you, Melissa. Right. We are very honored today that basically we have Poini here to share with us what about the COVID environment and what happened on the legal contract that we're going to face in the upcoming few months from now. So I think let's get it very quick and into it here. There's a few questions we are seeing here that we are able to go in. I think, Queenie, the first thing that a lot of people want to know, recently when the government has actually declared the 6 months moratorium, right? And after all this debate of legal power and all this environment came in, can you give us a little bit of background, right, about this on this argument? Do they have such a legal power to basically to mandate all the bank to provide a moratorium to all the borrowers?
Thanks for the question, Kelvin. Before that, I must thank Melissa for the introduction. It's absolute honor for me to be here today. To answer your question, Kelvin, thanks for the question as well. Whether the government has the legal power to compel the banks to offer blanket moratorium, the answer is yes and no. As a matter of background, earlier this year, our Prime Minister has announced that Malaysia is currently under state of emergency in view of the outbreak of COVID-19. 2 days later, on the 14th of January 2021, the Emergency Essential Powers Ordinance 2021 was gazetted. So on the 1st of June this year, the government imposed another lockdown FMCO, which lasted until today. There were therefore demands that the government should impose automatic blanket moratorium like how we did in 2020. So our finance minister was quick to respond that the government does not have such legal power to compel the banks to offer moratorium. So subsequent to this, there was counter argument to say that since we are currently under state of emergency, the government may invoke its power under the emergency ordinance to impose a blanket moratorium immediately. So go back to your question, Kelvin. It may be a no that they don't have such power because as it stands, there's nothing provided in the emergency ordinance about suspending loan repayment obligations between the borrowers and the bank. And in any event, even if the emergency ordinance can be used to impose moratorium, it comes with payment of compensation by the government, which is provided under the emergency ordinance. These will eventually add on to the burden of our government. So it could also be a yes that they have the power if they want to. They could just amend the emergency ordinance to include specific additional power to implement a blanket moratorium. So to me, the better way of looking at it would be whether it is necessary to have blanket moratorium.
Okay, so it seems that now under the state of emergency, we have no choice. A lot of things has been weak in terms of legal perspective. So probably from the borrower point of view, right? how does this moratorium different compared to the first round when they offer in 2020?
Sure. The first moratorium in 2020 was an opt-out basis, meaning it's automatic unless you choose not to participate. This round, it is the opposite. It is purely on an opt-in basis. The borrower will have to apply and satisfy certain conditions, such as there must be no default for more than 90 days. The borrowers will have to they are required to sign some documents if they choose to opt in, as a matter of to revise the terms to their original agreement. That's number one. Number two, interest. The interest on first round did not accrue on deferred installment. The latest moratorium here now in 2021, however, would not be interest free. It merely helps the borrower by deferring payment on installment to a later date. That there will not be any compounded interest or penalty charges during the 6 months, but interest will be chargeable. Those are the main difference.
So on a very simple basis, so when you say interest chargeable and there is a new contract that need to be signed, I mean, take it as a borrower perspective, right? For housing loan borrower, is all the rest of the legal fees still apply?
The additional documents that may be required to be signed, it may differ from one bank to another bank. So from my understanding, I cannot speak for all the banks, but from my understanding, the only document which require them to sign will be the supplementary letter offer. So there won't be any legal fees or stamp duty, but certain banks may require you to stamp the revised letter offer, which will be a 10 ringgit stamping fee, to be borne by the borrower, which is fair.
Okay, so it's a nominal amount that the borrower...
It should be, yeah.
Okay, so probably just to take care now, I think basically this is something a lot of consideration that will take place lately, right? So what is the main consideration of a borrower in deciding whether to opt into this moratorium in a legal perspective? What you thought about it?
I wouldn't say that this is legal perspective, but this is from a very practical perspective. To me, the only question that you need to ask yourself in deciding whether to opt in this round is to ask yourself, do I need this moratorium? So if you do have serious cash flow problems or the pandemic has affected your income badly, go for it. Have a breather and hopefully things will be better financially after 6 months. Well, there will be interest. Yeah, that is also a consideration. There will be interest, but it is secondary at this point of time. You're in a storm. Make plan to survive first. Find a way to pay in future. Personally, my view is opt-in is a better decision this round, as we cannot deny that the first moratorium did benefit the rich and some big corporation when they may not need this to begin with. This round, with the non-waiver of interest, there may be not much motivation for people who can afford to opt in. This way also it achieves the original purpose of only to help those in need. If you don't need but you opt in, pay additional interest. I think that's fair.
Okay, great. So I think on the bank side, normally what we actually look at it as a few of what they call that customers to actually apply to opt in. I think they can start officially opt in to apply today for all this moratorium. So we do advise some of the clients as well. When they actually opt in, they can actually take on the cheaper loan to basically to offset the more expensive loan. I mean, namely the credit card debts that is actually put in. So that will actually help in terms of liquidity. So this 6 months moratorium does really give us a what they call that a cash flows movement to ensure that we are able to self-sustain and to prolong a little bit what they call that our cash flow, to make sure that we are able to self-sustain for the next 6 months. So what do you think here on the next thing here, Queenie? What will be the legal implication to a borrower if they choose not to opt in?
Well, if they choose not to opt in, then it will be business as usual. Follow your original contract with the bank, serve your monthly installment as agreed. So if they don't opt in and they fail the installment, then the usual consequences will follow, such as you will have record on secrecy, there will be penalty charges, and legal action may follow if need be.
I see. Right, I think we have a question here from the chat here. Probably it's kind of related now, so let me bring this up. So, what is the threshold for winding up petition in Malaysia?
The threshold for winding up petition currently is 100,000, effective April 2021. Yeah.
100,000. Okay.
100,000. From 50,000, it is increased to 100,000 now. It used to be 50,000 before 1st of April 2021.
Okay. So which means that what we are seeing that it has widened the band slightly so that people have more time to. This is more breather for the petition or wind up.
I would say that maybe the government is trying to make it harder for a company to be wound up now, because yeah, they set the threshold higher now.
I see. Okay. Well, I think there is this is basically some clarification that they put in here. One of the guests is also asking, is this also due the incremental is basically, is it due to the COVID Act?
The increment of you mean the increment of the 100,000, right? The threshold.
Yes.
Okay, not directly. I wouldn't say that it is not directly, but perhaps the whole pandemic scenario may have given rise to this, because COVID Act increased the bankruptcy. I'm actually going to touch on that as well. The COVID Act increased the bankruptcy threshold from 50 to 100,000. That's provided expressly under the COVID Act. And this may have, in a way, intended to make it harder for individual or company to be made bankrupt or wound up as a result of the pandemic. So in any event, under Companies Act, the minister may, from time to time, by way of gazette, prescribe the amount for a company to be wound up, prescribe a minimum amount. Yeah, so this time, the latest gazette, which takes effect 1st of April 2021, it says that now to wind up the company, the minimum debt should be 100,000.
I see. So now being said so, right? So just now I think you mentioned that if the company choose to opt out, right? So what if the customers already opt in, right? Or most of the company has already opt in is during moratorium period, but later they fail to serve the installment when the moratorium is over. So what's going to happen to them?
Okay, as it stands, the moratorium and extension of protection under the COVID Act will end on the same day. So moratorium is 6 months, so it will end on the last day of 2021. The protection given under the COVID Act will end on the same day as well. I think this is intended, yeah. So hence, technically, unless it is further extended, it will be business as usual after the end of this year. But assuming the scenario will be the moratorium end on 31st of December 2021, and the extension under the Act is further extended. Then in that scenario, there will be two types of borrower under this scenario. So the first being the type of loan which is covered under the COVID Act. I'm going to touch on COVID Act later to give you a clearer explanation. So if the type of loan you're having with the bank is being protected under the COVID Act, for example, hire purchase or any installment payments for home appliances, then the bank is still bound under the COVID Act to not do anything, not take any legal action against you until the extension of COVID Act is over. So let's say, on the other hand, if your type of loan is not covered under the COVID Act, for example, housing loan, personal loan, those are not covered under COVID Act, the moment moratorium is over, you are obligated to make installment payments. It will be business as usual.
Okay, but I think you do touch about the COVID Act. Maybe you can elaborate further about COVID Act. What does it covers under COVID Act?
Okay, COVID Act came into force on 23rd of October 2020 last year as part of the measures taken by the government in coping or reducing the impact of the pandemic. So how would COVID Act affect you as general Malaysian? So let's say if you are a business owner who has entered into any types of agreement in the course of your business, or you are a supplier who has promised by way of PO, etc., to supply any goods. If you are a contractor supplier who has given performance bond, if you are a service provider who has undertaken to carry out any types of services, or you're a tenant landlord who has entered into tenancy agreement, a car owner who is financing your hire purchase loan, or you are a purchaser who is waiting for delivery of vacant possession of the housing property, you would wish to find out whether you will be penalized like you usually would if you fail to carry out your obligations during the pandemic. Yeah, that's COVID Act.
Oh, it's a long list of
Yeah,
items.
you know.
Okay, so I'm just capturing what you mentioned just now. I mean, something that probably more layman to the listeners and also our customers here. I think a lot of them will probably might want to know that the landlord will enter into a tenancy agreement. So this moratorium only applied to the what they call that the landlord. Then how about the tenancy agreement? How does it impact that?
Okay, let's say if you enter into a tenancy agreement, but here I'm only talking about commercial property. It's only a COVID Act only covers commercial property. I think that's for SME purposes. So let's say if you fail to pay any of your rental during the pandemic period, during the period covered under COVID Act, the landlord actually cannot take any actions to evict you out from the property. Meaning I feel under the original tenancy agreement, it is usual for tenant to make payment every month, and if you fail to do that, there will be consequences which follow. Yeah. So, but with this act, basically the landlord is bound not to do anything until this is over. That's the summary of it.
Yeah. So in summary, do we still need to pay?
You have money, you pay. You don't have money, they also cannot do anything. It will be that kind of situation.
So which means after the moratorium, right? Basically, the whatever payment that we have actually due, it will be carried forward. That the tenancy have to continue to do the payment. It will turn into what they call that monthly installment again, or is the whole 6 months consider the landlord cannot do anything? Yeah.
No. Okay, for a very simple landlord and tenant situation, it will be a situation where this amount remain due to me, unless I have settled to compromise a lower sum. Like a lot of landlord is giving 30% discount during the first during the first MCO. So unless I commit to take lower amount from you, if not, this amount that you are going to pay to me monthly will be accumulated until you are able to pay. Eventually, when all this is over, you have to pay the same amount. It's not being waived.
Whatever owed also have to be paid, right?
That's right, unless I compromise to take a lesser amount.
Okay, great. So basically, what are the types of contract that has been covered under this COVID Act?
There are 9 types. If originally 7, eventually another 2 being added. I'm going to read out to you, which won't be long. So the first being construction works and its related contract, performance bond pursuant to construction or supply contract, professional service contract, lease tenancy of commercial property, only commercial property, event contract, tourism related contract, religious related contract, hire purchase and credit sales contracts under the Consumer Protection Act. Though the credit sales contract meaning those purchase of furniture or home appliances by way of installment. Those are the 9 types.
Okay, so in the event that all this contract, those out of this contract, so they are not covered under the Act, so what can they do?
If the type of contract that you have entered into, it's not part of the lease, as I mentioned earlier, you will not have any protection under the Act. Basically, COVID Act lists down these 9 types of contract under the schedule of Section 7, Part 2. They are only giving protection to these 9 types of contract. So if your contract is not part of this, for example, housing loan, personal loan, credit card, it's not part of it, you will have to, unless moratorium kicks in, if not, you will have to make your usual payment. You have to perform. It is not only about payment, it's about performing your contractual obligations.
Okay, so it seems that this moratorium going to give a lot of business to the lawyer then. Okay, so let's move on. I think this is something interesting here, right? Can you let us know potentially what will be the shortcoming of the COVID Act?
Okay. There are a few. Delay. The first thing I'm going to say, which I think it's really the biggest shortcoming, will be the delay. The COVID Act, this act was gazetted in October, 23rd of October 2020, 7 months after the first MCO. Although the act has retrospective effect, meaning it actually, when it is published in October, but it actually takes effect from March, 18th of March 2020. But there's a saving provision in Section 10, which states that any contract terminated, any deposit, performance bond forfeited, any legal proceedings commenced from 18 March 2020 to October 2020, the 7 months period shall be deemed as valid. Hence, the shortcoming being, this may come a little bit too late for certain parties who already suffered the consequences of measures taken before they are afforded the protection under the Act. Should the Act comes in time or earlier, they would have been spared from such loss and suffering. So as a matter of comparison, Singapore COVID Act equivalent was passed on 7th of April 2020. So this shows a better preparation of the Singapore government in coping with COVID pandemic. That's the first. The second one will be the wording used in the Act. So the wording in Section 7 says that the inability to perform or inability to pay. Yes, whilst we understand the meaning literally, what is inability to perform or inability to pay, but we don't know to what extent. There's no case law because it's too early. It's less than a year. This Act is new. There's no law showing us, there's no case law to show us the benchmark or test to such inability. We are still unsure whether it has to be a direct consequence of the measures taken or a contributory or indirect factor would be sufficient. I give you an example, Kelvin. So for example, if I'm a pharmacy owner, I was allowed to work being essential throughout the MCO, but business is so bad that no one wants to come out and buy. So as a result of this, I have financial hardship to pay my rent. Yeah, so does Section 7 apply? It's arguable. If I'm the pharmacy owner, I would say yes, because measures taken during MCO have an impact on my business. It has caused me cash flow issues. Hence, my inability to pay rent is caused by the measures taken. The measures taken being, they cut short the operation hours, they limit the crowds and all this, so it affects my business in a way indirectly, although I'm allowed to open. So on the other hand, if I'm the landlord would argue that the cash flow is not a direct consequence of the measures taken. The measures taken may have affect your business, but you're allowed to operate. It may be your mismanagement of cash flow, which resulting the inability to pay. And to be fair, it is also not fair to the landlord, who is also a victim, to continue to expect no payment until the whole thing is over. So what is going to happen when you have a situation like this? There may be a high likelihood there will be more court cases as parties will be in dispute to whether there was a genuine or proper inability to perform as set out in the COVID Act. So more people will be going to court to find out whether this is a genuine case of inability to perform. So that's number 2. Number 3, the mediation. Under COVID Act, they provide a out-of-court avenue by way of mediation, but it is voluntary in nature, unlike Singapore. Voluntary in nature meaning the government is not going to compel anybody to try to mediate first before going to court. So it is also subject to both parties' agreement to agree to mediate. So which means if I don't agree, if I'm one of the parties and I don't agree to mediation, then this method won't work anymore. So it defeats the purpose. And last of the shortcoming will be, okay, the intention of Parliament should be like this. It must to allow contract enter prior to the first MCO to have enjoyed the protection. But the wording in the Act is such that it includes contract that is entered during the pandemic period to still be able to enjoy the protection of the Act. So why is this a shortcoming? Because before MCO 1, the businessman or anybody wouldn't have anticipated the lockdown or close of business, and it would be only fair to spare them from the consequences when they are unable to perform. But if you enter into contract during pandemic, you would have already taken into consideration the risk and the ongoing pandemic atmosphere. So this is unfair for the non-defaulting party. So as a matter of comparison against Singapore, the cut-off date is clearly stated in the Act. So any contract that entered before February 2020 in Singapore, you enjoy the protection. Anything that is after, you don't enjoy the protection. But that's not the case in Malaysia.
Wow, so the word inability to pay and the mediation that you mentioned, right, is very, very subjective now, right?
It is. It invites more dispute, I would say.
Yeah, so what is your stand? So the inability to pay is how they define that?
It's also, I will still, it depends on which stand. If my client is the one who wants to enjoy the protection, then I will argue that the inability to pay should involve the indirect or contributory factor. This is the position I will be taking. If I'm acting for the other side, the non-defaulting party, then I will say that the inability to pay must be the direct consequence of the measures taken. So it depends on which stand you are taking.
Okay, so it's kind of complicated here. So I think the right answer here will be choose the right lawyer. Right?
Yeah, that's
so
right.
That basically will help us to settle this. All right. So just put aside here. So I think let's go in a little bit more detail about this COVID Act here. The COVID Act seems to give protection on the defaulting party. So what about the non-defaulting party? So what can we do, right? When a party that actually owe another party and they decided not to pay, and the Act is protecting them at this moment. So what can we do to those the non-defaulting party?
Yeah, the party who is not at fault. They are actually victim as well. They are equally aggrieved. So as I mentioned earlier, there was a section under Section 9 of the COVID Act, which provides an out-of-court avenue for parties to settle any dispute. That's mediation. Yeah, this is the only remedy to the non-defaulting party. So there will be a COVID-19 mediation center. They have already established to facilitate the mediation of dispute arising from any of the categories under the schedule. So with this option, the non-defaulting party do not have to go through the lengthy or expensive court process to recover the money owing to them, etc. So if settlement is reached by way of mediation, a settlement agreement will be prepared by the mediator, and it has the same legal binding effect on parties. So this way, the only advantage to the non-defaulting party is I save costs if provided the other side, my counterpart, is agreeable to such mediation. Then I will save costs. I will save the lengthy court process. Yeah.
I see. So okay, I think before we go on, there's one question here. Can I know what is the duration of the COVID Act? So does it only cover during the moratorium, or it cover the whole FMCO's MCO period?
The duration of COVID Act is actually 2 years from the date of Gazette, which means it was gazetted on 23rd October 2020, meaning it will be around until October 2022, 2 years.
I see. Okay, so I hope we answered that question. So does the FMCO or EMCO covers under the COVID Act?
It is currently the latest announcement on 30th of June. So based on the latest announcement, only part 2, the 9 types of contract that I have mentioned, it's currently being extended until end of this year, 31st December 2021.
Okay, well, what if it get extended after end of the year?
If it gets extended, then we will continue to enjoy the protection.
So, I mean, that is on the defaulting party, but the non-defaulting party, they will get continue suffering, right?
That's right, which is really not fair.
How does it imply? Because on the one hand, the non-defaulting party will have difficulty to take a legal action and yet cannot repossess the assets, right?
That's right.
So how does this imply? Is there any act that is actually protecting the party on a fair basis?
Let's say we take the simplest, let's say the type of contract that you mentioned, the scenario that you have given is protected under the Act, which means the 9 types of contract that I mentioned. And let's say there is really no payment from the defaulting party, and it keep extending to the extent that it's now like a year plus, so it keep extended until say early next year. The only recourse for the non-defaulting party is to refer this matter to mediation and hopefully achieve a win-win situation from the mediation. You may have the contract terminated and receive some compensation as well when it goes to mediation.
I see. Okay. Will this extended? This one we have covered. Right. So I think that this is basically we have a question on about Pemulih moratorium is until December 2021, right? So I think it really subject to the banks at this point of time. Like for example, on behalf of Afin, what we can say, we only provide 6 months moratorium, which is starting today. Basically, you can actually apply, and it will carry on until end of the year, right? So it's very simple for you to apply with in-bank moratorium. You just go to our website. There's a form that you can download that and just fill it up and submit back to us online as well. So there's no approval required. It's just that you need to opt in if you really want to ask for a moratorium for your loan. All right. So I think I hope I answered the questions that's on the chat room. So ladies and gentlemen, you can still ask more questions. I think Queenie still have a lot of things that she can share. Anything that you would like to ask, particularly on your business, your SMEs, contract that you require support when it comes to this COVID Act and this during moratorium environment. Queenie, while waiting for that, I think there's one question still coming in here. We are talking a lot, particularly in Malaysia, right? So for those business that actually do contact with overseas, I think particularly our neighbor, right? Can you make a brief comparison? How do COVID Act equivalent being carried out in our neighbor country? So if I have business with a neighbor, what are we going to have that?
Okay, this is actually one of my favorite topics to make comparison with our neighbor Singapore. It is really very well prepared. Okay, so let's make comparison with our neighbor country, Singapore. So there are a few things which I think we really can learn from them. So first being, still I go back to the wording used in our COVID Act, the inability to perform or inability to pay. It is being very carefully worded in Singapore that the inability must be to a material extent caused by COVID-19 event. So in Singapore, if there's any dispute whether a person is entitled to a relief under their COVID Act, an independent assessor will be appointed to determine and decide on the dispute. So this way, it actually saves parties on the potential dispute before even going to court to determine whether you are qualified for such relief. Number two, that's for the wording used in the Act. Number two, the mediation. In Singapore, the mediation is a very quick and easy determination. Parties generally will not be legally represented. You don't need lawyer. The assessors will be appointed to make decision on what is just and equitable based on the circumstances of the case. Okay, the last comparison that I'm going to make is LAD. You see Malaysia's COVID Act exclude calculation of LAD from the first MCO, 18 March 2020 to 31st August 2020. So this exclusion of calculation of LAD, it's only applicable to developer and purchaser under HDA contracts, Housing Development Act. In Singapore, they go further to afford the same protection to contractors for purposes of calculating their LAD liability to their employers under the construction contract, which is a better planned and considered approach. But of course, having said that, a contractor in Malaysia, let's say you are not being covered, we don't have the express session for it to cover you. So this is also not the end of the world to them. They can also rely on Section 7 of the COVID Act, because remember, one of the types of contracts that is being protected is construction-related contract. So they may also rely on that to relieve their inability to perform their contractual obligation. Those are a few that I can share with you here.
Okay, so it seems like both countries are well prepared. It's just that we probably need, again, back to the same questions, right? We really need to understand who's the lawyer that we are picking up so that we actually have ourselves protected. Right. Yes, I think we have a question here, right? Basically, can we request the bank what will be the payment on a monthly installment be if we opt in Yes, the answer is yes. Of course, you can actually check with the bank, depending on the loan that actually you have with the bank, and the bank will able to give you a calculation. So in a simple term, basically, how we actually do the calculation is we take whatever that you need to pay for the next 6 months, and they will be actually calculated amortization for you for the remaining years of the loan. So that will actually give you a rough idea what sort of installment plan. But to get an exact number, yes, you can. You can actually write in. The bank will be able to assist. Right. Right. Okay. One more question coming in. So does the developer continue to enjoy the protection for late delivery for vacant possession under the COVID Act or under this FMCO or this EMCO? Right. Back to a very layman questions. If I buy a property today and because of this FMCO and this EMCO, they are not able to fulfill the timeline of the development, right? So do the developer continue to enjoy the late delivery of the vacant possession?
No, in fact, under the Act, the developer has never enjoyed the late delivery of vacant possession. They have never. The only thing that is expressly excluded is the calculation of LAD, and that is only for the period from the first MCO, 18 March 2020 until 31st August 2020. Whatever extension that I mentioned to you, in fact, extension has been extended 3 times, yeah, including this round, but it was never given to the LAD. So there is no excuse for them to hand over vacant possession late to you, but it only excludes that few months, that 5 months of calculation of LAD when they hand over to you. Did I answer your question?
Okay, so I hope you answered the question. That basically there is no special privileges for all the developers.
That's right. Only the LAD is being excluded for that period, for that 5 months.
Okay, right. I think wow. So okay. So this again. So if we opted in a 6 months deferment, this amount will be accumulated in the same contract timeline. So if we opted in the 6 months deferment, this amount will be accumulated for the same contract timeline or the timeline contract extended. All right. So I think we have this question from this guest. So if we opted for 6 months deferment, will the amount accumulated for the same contract timeline or it will be extend of the timeline? Well, I think this you need to go back to the bank. In Affin Bank perspective as well, you will go back and you will actually look at the loan types that you're having with us. For this, some of the loan, we will be actually put it back into the same contract timeline, and other of the loans, we will actually extend the timeline. So this is again, it depends on the loan type that you have with the bank. Right. Okay, so let's go on to another questions here. Now, I think after listening to all this burning complications in terms of the COVID Act, now, any advice that you can actually give us for future contract for better protection over this pandemic scenario?
Okay, it will be the force majeure clause. It's very common for all the contracts in Malaysia, or rather in all over the world, to have this force majeure clause, which is mainly to cover for situations such as act of God, war, etc., which is beyond parties' control. This is normally quite a standard clause, which we don't make much amendments to it. But this pandemic may have made us realize that the clause may not have covered pandemic, although it is equally beyond our control, but we may not be able to rely on this clause to breach the contract, so to say. Yeah. So there is no one-size-fits-all solution, but I would advise parties, especially in business, to take this pandemic opportunity to review the contract, identify the situation as listed in your force majeure clause, and consider whether it is sufficient to cover a situation like this in future. That's number one. Number two, consider whether there are mitigating circumstances provided in the contract, like how are you going to mitigate losses when this happen again in future. Number three, if new contracts are being entered, specific provisions covering the eventualities to cater for pandemic or equivalent situation need to be properly considered and drafted. And last, considering a win-win situation rather than ending the business relationship. That would be my advice for future, for better protection in future contracts.
Okay, probably point taken on the close measure, because normally the closure clause is basically just leave it there and it will just continue copy paste most of the time.
That's right. That's right. We seldom make amendments. That's true.
All right. So I think what one of the clients asking, is possible or not possible that we are able to download or we are able to have a copy of the COVID Act available, make available for any of us here?
You may actually Google. Sorry, I need to give you the full name of the COVID Act. It is actually not known as COVID Act. It has quite a long name. Sorry.
All right. Mike, what we can do is maybe just put it into the chat.
Yeah.
Right. So again, here under the commercial tenancy agreement, does it mean that the tenancy A, they will get withdrawal or cancel the agreement earlier without any charges? Is there any legal implication of it?
Sorry, can you repeat your question, Kelvin? So my line is a bit lag here.
Yeah, so there's a question on the under the current commercial tenancy agreement, does it mean that the tenants get to withdraw or cancel the agreement earlier without any charges?
No, you have to stick to your original agreement as per your commercial tenancy agreement. What is allowed or what kind of protection that's given under the Act is if you fail to make payment of your rental, the landlord cannot use this as a reason to evict you, that's all. It doesn't say is that it gives you the opportunity to terminate it and get away with it without any cost. It doesn't mean that.
So which means even though if we do the early cancellation, there is still a legal implication on the contract?
Unless it is being mutually agreed upon between you and the landlord to have it mutually terminated, that's fine. If not, you have to follow the original terms of the contract. Except for the payment part, it may be delayed. You still owe them this same amount of money, just that you may defer and they cannot take any action against you during this period of time.
I see. Okay. Right. So there's one more question here. The rising of the bankruptcy and the winding up threshold to 100K, is it just because this during COVID period, or after this it will move it back down to 50?
For winding up, it will maintain 100,000. Yeah, because as I mentioned earlier, the winding up threshold is being determined by the minister under Companies Act. So indirectly, it has nothing to do with COVID Act. So it will maintain at 100,000 unless it is otherwise directed by the minister by way of Gazette. Yeah, that's as far as this is concerned. Bankruptcy Act is being increased from 50,000 to 100,000 due to COVID Act. So as I mentioned earlier, COVID Act has a duration of 2 years. But the latest insolvency bill, they also intend to increase the Bankruptcy Act to 100,000. So there won't be any changes for now.
Okay. Now we have a clients that's very good that actually have posted the COVID Act on the chat room. So
thank you so much.
Require it, please do feel happy to basically click on the link. It will bring you to an external website to take down the act. So this is by the government website. Thank you very much, the client that posted that. Okay, well, I think we have more information and loaded a lot of information today. So we can still take on another 1 or 2 questions if there is any, if it's any more things that you would like to understand more from the lawyer itself, and just hear from it what kind of things that we can do. Right. Well, I think while waiting for that, probably Queenie, can you elaborate further, particularly on this COVID Act, right? So what happened further after 2 years, and basically there is no extension, right? So what will happen after that?
It will be business as usual, meaning after 2 years, when the Act is no longer in force, then you will have to go back to the time when, as if this act has never happened, and you no longer enjoy whatever protection or relief that is granted under this act. It will be business as usual.
Okay. All right. So, okay, I think there's most there. There's probably one last question from the email portion here.
Yeah.
Well, okay, so this is basically, let's see. Okay, so I guess this question is basically why different banks apply different moratorium system. I guess the bank will have their own risk calculation. Therefore, every bank will have their own different mora implementation. So to understand better, it's good that you actually go back to your banks that actually give you your loan from to understand the moratorium. I think for Affin Bank, our moratorium is we have two types. Basically, you defer, or there's a 50% of the monthly installment. So this is again is opt-in scenario. You can apply through online so that you are able to enjoy this moratorium period. All right, I think we came to the end of the session here. Thank you very much, Queenie, for your time, and thank you very much for all the clients. Of course, we will still be able to take questions. You can just email to us any questions that pop up your mind that you would like to understand more. We are happy to assist and to send it over to Queenie to get a answer and to reply to you officially. So the email is actually stated in the chat room or not. It will be under wealth segmentation at affinbank.com.my. So you can able to send other questions in so that we are able to give you, if we have not able to answer all the questions that you want to ask today. Right. I hope this session has given all of you a little bit understanding on this moratorium and COVID Act, what benefits us and what benefits the current scenario. Should you or should you not actually opt in or opt out as well, right? So this is something what they call that information that you can actually digest it, right? And you will able to make a decision after today. So should you or should you not opt in? All right. So with this, thank you very much for your time. Have a great evening, and thank you again for joining us on this webinar. Thank you from Muffin Bank.
Thank you, everyone. Thanks, Kelvin.